Hello everyone, we welcome you back to our channel. This is Legal Mindset Adeba, and today we have answered your calls and we are diving into Evidence Law 1. We are going to handle it topic by topic. So if you want to dominate a thing, you should start from its beginning. And in today's video, we are going to look at the introduction to evidence law. We are going to define evidence. We are going to define what is evidence law. We are going to also give the key terms used in evidence law and the types of evidence. So I beg you to subscribe such that we continue. Okay, thank you for subscribing. Those of you who have hit that subscription bar. Now, to define evidence, Tyler defines evidence as all means exclusive of mere arguments which tend to prove or disprove any matter of fact, the truth of which is subjected to judicial investigation. Now, that is the definition of evidence according to Tyler. The word evidence is derived from the Latin word evidence or evidere, which means that show clearly. You get show clearly. To make it clear to the sight, to discover clearly, to make plainly certain, to ascertain or to prove. All those are meanings of evidence. And if you go to the Evidence Act, Cap 8, Section 2, it defines evidence to denote the means by which any alleged matter of fact, the truth of which is submitted to investigation, is proved or disproved, and includes statements by accused persons, admissions, judicial notice, presumption of law, and ocular observations by the court in its judicial capacity. I'm giving you many definitions because I know our preferences are different. Now, to define evidence law, you can define it as a branch of law that governs laws and the legal principles that regulate the proof of facts in legal proceedings. Now, if you continue on to go to the case of R versus Klibaune, a case reported in 1974, the House of Lords held that evidence is information by which facts are investigated and proved. The law of evidence, it also went on to define the law of evidence as a body that regulates the rules of evidence regarding its facts proved or disproved in the courts of law. And the case of Klibaune is very good because it defines for you evidence as information by which facts are proved or disproved. It also defines for you the law of evidence as the body that regulates those facts, the proof of its proof or disproof. And if you go to the Ugandan case of Nsubuga versus Uganda, case reported in 1979, court stated that evidence is the means by which the alleged matter of fact is rendered true or false according to investigation. Now, we cannot put back the Blackstone Dictionary 12th edition because it defines evidence more clearly. It says that, and it defines evidence as the testimony brought in the form of documents, brought in the form of write-ups, hearsay, audios that prove or disprove a fact in issue of any alleged matter. That's the Black's Law Dictionary 12th edition. And I suppose those definitions are enough for you to define evidence. Now, there are various definitions you can find out. Let us look at the key terms used in evidence. Let us look at what is a fact. If you go to section 2 of the Evidence Act, it defines a fact as anything state of thing or relation of thing capable of being proved or disproved. You can also look at it as the mental condition of which and a person is conscious. That is a fact. You can go to the facting issue. Now we have been looking to a fact. A facting issue is defined in section 2 of the Evidence Act also. That one is like the fact which includes facts which are more relevant to the proceedings in court, which are more necessary to follow by court. Now, let us look at the types of evidence. We can look at the oral evidence, which means all statements which court can permit to be made. That is the oral evidence. We can look at section 2 of the Evidence Act also. We can also look at section 2, subsection 1 of the Evidence Act defines oral evidence as to mean all statements which the court permits or requires to be made by a witness in relation to the matter of fact under inquiry. Now, let us look at another type of evidence, the documentary evidence. All of these ones, most of them are defined in section 2 of the Evidence Act. And documentary evidence was defined to mean evidence of all documents produced to court when a fact is like when there is a proceeding in court. We can look at the real evidence. This one is known as the material or physical evidence. We can look at the direct evidence, which is evidence of a person directly perceived from a facting issue. We can look at circumstantial evidence or indirect evidence, the evidence inferred from the things relating to the facts, the subject matter of the case. You can look at very many types of evidence, the prima facie evidence. Can look at the opinion evidence. In opinion evidence, the general rule is that opinion evidence is not admissible, though as a general rule, there are exceptions. Evidence of experts is admissible. So, you can also look at canine evidence. So now, that has been our introduction to Evidence Law 1. I think that introduction has been very key to your understanding of evidence law. We are going to attempt other topics in evidence law, section by section on this channel. Subscribe and we move together if you want to understand evidence law 1. If you need any sort of mentorship, our numbers are there in the description box. Don't fear to contact us. We shall make you reach that person who has the capacity to help you change your grades. Thank you very much. This is Legal Mindset at the Bar. Subscribe.